Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about liability in auto accidents. Cases that should have gone to the Supreme Court of Canada, but didn't. In an accident that occurred in British Columbia, the driver was found to have committed the offense of dangerous driving causing death and causing bodily harm, and impaired driving causing death and bodily harm. The driver was convicted, but the vehicle that the driver was driving actually belonged to a dealership and had been given to somebody who knew the driver through a friend of a friend as a result of their intention to purchase the vehicle. So the person who was borrowing the vehicle from the dealership had the vehicle for a period of 10 days under the dealership's essentially agreement to allow her to continue to have the vehicle. She gave permission to a friend to drive the vehicle during this 10-day period, and her friend let the driver, who was ultimately involved in the fatal collision, drive the vehicle during that point. And a civil lawsuit was brought against the owner of the vehicle because under the BC Motor Vehicle Act, the provisions of the Motor Vehicle Act make an owner liable for anything done with the vehicle. Owner is defined in a complex way in the BC Motor Vehicle Act, in that if a person is leasing a vehicle with a potential to purchase the vehicle at the end of the lease agreement, then they may also be an owner. And so in the circumstances, there was a big question about who was the owner of the vehicle and whether or not there was consent given for the person who ultimately was driving it in the collision to drive the vehicle, because there were multiple layers of consent, from the dealership to the person they had loaned the vehicle to, the person the loanee had loaned the vehicle to, and then to the person who took the vehicle. And this case obviously raises important issues about civil liability in the grander context, especially when we have provisions that make individuals liable for the actions of other people. Think about host liability situations, and situations where somebody takes your property and uses your property, but with your consent. To expand the definition and the situations in which people can be successfully sued for not exercising proper care and judgment to situations where there are so many layers between the parties is dangerous territory. It risks there being far more lawsuits being filed. It risks the complication of our civil justice system by increasing the number of parties that are being sued, and also thereby increasing the number of people who might be financially liable and the determination of damages, and increases a multiplicity of proceedings in these types of cases. It's unfortunate that this case didn't get leave to the Supreme Court of Canada so that the Supreme Court could have reined in this use of the civil justice system in combination with statutory provisions that make owners liable for things that happen with their vehicles in ways that ultimately leads to an increased burden on our justice system. And unfortunately, the Supreme Court of Canada didn't take that opportunity, and we're probably going to see, especially in other provinces where you can still sue as a result of a motor vehicle collision, we're going to see a lot of proceedings take place on these very shaky relationships between owners and operators of vehicles or other types of property. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.